ఈడబ్ల్యూఎస్ రిజర్వేషన్ను సుప్రీంకోర్టు సమర్థించింది. సుప్రీంకోర్టు ప్రధాన న్యాయమూర్తి జస్టిస్ యుయు లలిత్ నేతృత్వంలోని రాజ్యాంగ ధర్మాసనం తీర్పు వెలువరిస్తోంది. అక్కడ నుండి లైవ్ చూద్దాం.
They may not be the state or state instrumentalities, yet the value that they add is part of the national effort to develop skill and disseminate knowledge. These institutions, therefore, also constitute material resources of the community, in which the state has a vital interest and are not merely bodies set up to further private objective of their founders, unlike in the case of shareholders of the company. Therefore, I hold that on question number 2, the amendment is valid, but for reasons of answering question number 3, the amendment has to go. Before I sum up, I wish to address one point which the majority has dealt with, but more as a note of caution, because it is not necessary for me to deal with that aspect, which is the 50% cap. It is pertinent to note that the breach of the 50% limit is the principal ground of attack of the 76th Constitutional Amendment, 1994, which is inserted as entry 257A. The Tamil Nadu Backward Classes, Scheduled Caste and Scheduled Tribe Reservation of Seats in Educational Institutions under the State Act 1993. The validity of that enactment and whether the inclusion by the Constitutional Amendment violates the basic structure is directly an issue in a batch of cases pending before this court. The view of the members of this bench constituting a majority that the creation of another class which can be a recipient of up to 10% of reservation over and above 50% permitted under 15.4 or 16.4, in my considered opinion, therefore has a direct bearing on the likely outcome in the challenge in that proceeding. I would therefore sound this cautionary note, since this judgment may well seal the fate of the pending litigations without the benefit of hearing in those proceedings. The last reason why I find myself unpersuaded to agree with the opinion that the amendments, by creating a different kind of criteria, have to be viewed separately, and that Indira Sani was confined to reservations under 15.4 and 16.4, is because permitting the breach of the 50% rule, as it were, through this reasoning becomes a gateway for further infractions, which in fact would result in compartmentalization. The rule of reservation could well then become the rule of equality, or the right to equality, could then be easily reduced to the right to reservation, leading us back to the days of Champakam Durai Raja. In this regard, the observations of Ambedkar have to be kept in mind that reservations are to be seen as temporary and exceptional, or else they could eat up the rule of equality. The fraternal principle, I am now summing up, the fraternal principle is deeply embedded to this nation's ethos and culture. The specific provisions which form part of the Equality Code are inextricably intertwined with fraternity as well. It is fraternity and no other idea which acknowledges that ultimately all individuals are human beings born through the same natural process, subject to the same physical limitations, and finally leave this world at an unknown time, but are sure to live. Fraternity is as a concept, awakens humans to the reality that despite our apparent or superficial differences, ethnic, religious, caste, gender, origin, or economic status, the institutions we create need our collective cooperation and individual commitment. Every social order invariably contains individuals with differences, be grounded on ethnicity, wealth, talent, or realization of one's abilities. The diversities abound. The idea of fraternity is to awaken to the consciousness of each member of society that our institutions which are created, the ideas that we develop, and the progress that we wish to achieve cannot be in isolation, by separation, but with cooperation and harmony. On this, I want to highlight the words of two social reformers, which demonstrate that the principle of fraternity and the ideas and values connected to it are not new, but in fact transcend time. Swami Vivekananda's message in his address to the World Parliament of Religions in Chicago on 11 September 1893 has the theme of universal brotherhood of all. The differences in religion, the exclusion of one of other would fade. He evocatively said, if anybody dreams of the exclusive survival of his own religion and destruction of others, I pity him from the bottom of my heart and point out to him the hammer, the banner of every religion will soon be written in spite of resistance, help and not fight, assimilation and not destruction, harmony and peace and not dissension. Aurobindo too was conscious of the need for fraternity. In a speech delivered in Howrah in 1909, he presciently said, again, there is fraternity. It is the last term of the gospel. It is the most difficult to achieve. Still, it is a thing towards which all religions call and human aspirations rise. There is discord in life, but mankind yearns for peace and love. This is the reason why the Gospels will preach brotherhood, which preach brotherhood, spread quickly, and excite passionate attachment. This was the reason for the rapid spread of Christianity. This was the reason of Buddha's spread in the country and throughout Asia. This is the essence of humanitarianism, the modern gospel of love for mankind. None of us have achieved our ideals, but human society has always attempted an imperfect and limited fulfillment of them. It is the nature, the dharma of humanity, that it should be unwilling to stand alone. Every man seeks the brotherhood of his fellow, and we can only live by fraternity with others. To all its differences and discords, humanity is striving to become one. Summary of findings in questions 1 and 3. On question 1, it is held that the state's compelling interest to fulfill the objectives set out in the directive principles through special provisions on the basis of economic criteria is legitimate. That reservation or special provisions have so far been provided in favor of historically disadvantaged communities cannot be the basis for contending that other disadvantaged groups who have not been able to progress due to the ill effects of poverty should remain so, and the special provision should not be made by way of affirmative action. Therefore, the special provisions based on objective economic criteria is per se not violated. However, in answer to question 3, I have highlighted the framework within which it has been introduced by the impugned amendment, excluding backward classes. According to me, this is violative of the basic structure. A universally acknowledged truth is that reservations have been conceived and quotas created through provisions in the Constitution only to offset fundamental, deep-rooted generations of wrongs perpetrated on entire communities and castes. Reservation is designed as a powerful tool to enable equal access and equal opportunity. Introducing the economic basis for reservation as a new criterion is permissible. Yet, the othering of socially and educationally disadvantaged classes, including SCs, SCs, and OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability. The exclusionary clause operates in an utterly arbitrary manner. First, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of the society. Secondly, for the purpose of new reservation, the exclusion operates against socially disadvantaged classes and castes absolutely by confining them within their allotted reservation quotas. Thirdly, it denies the